Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the January 12th, 2022 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, sitting today with Justice Joseph Ditkoff and Justice Catherine Hand, and we will be your panel today. Calling our first case on the list, docket 2021 P219, Wright versus Massachusetts Department of Correction. We will hear first from the appellant, Mr. Wright.
Good morning, Your Honor. Good morning, panel. What I'd like to bring to the court's attention is simply, in this case, the court's aware of the facts, aware of the case. There was summary judgment granted that they shouldn't have been granted in this case. First, on the photographs being deemed sexually explicit and excluded. The record is clear that none of the photographs, which is part of the record, are not sexually explicit. They don't meet the definition of sexually explicit, not in appearance, not in the form. In this case, the lower court, when it granted summary judgment on this particular issue of misidentification, the court reasoned that the defendants were using the term sexually explicit as nudity in conjunction with one or the other as a short phrase for the whole thing. That's incorrect. And the reason why I want to bring it to the court's attention is simply, if you go to the male officers, when he first denied the photographs as sexually explicit, he was quite clear that they were sexually explicit. In his admissions, he admitted to it. In admission number 2324, volume 3, 285, he specifically states that some of the photographs are sexually explicit, which are not. Again, Defendant Phelps, the deputy superintendent, he says in his interrogatories and in his admissions that, again, the photographs depict actual or simulated sex. I think that, Your Honor, I think you guys are aware, you've seen the photographs, that's in none of them. Now, the fact that he says that in discovery, and the fact that even Kenaway, Parole, all of the other defendants says the same thing, the photographs are sexually explicit, I think that goes to show that the judge was wrong in saying that it was a short term or a short phrase. They intentionally misidentified these pictures to exclude them. And therefore, the court, there's no way that the lower court should have granted them summary judgment. That should have been summary judgment in my favor on the misidentification of sexually explicit.
Mr. Wright, let me interrupt. Mr. Wright, this is Judge Neyman. Let me interrupt you very briefly.
Yes.
My first question is, I believe according to the record, and you can correct me if I'm wrong, that there was also a finding or determination at some point made that the photographs at issue depicted nudity or partial nudity.
That's the next thing I was getting to, yes.
Okay. Now, before we move forward, something that's very important for this court to determine at the outset is what is our proper standard of review. And in reviewing this, you say that our review is de novo. That means we look at this fresh with no deference. My understanding is that when we look to a regulation that pertains to an agency, that we are supposed to give some deference, or in other words, if an agency makes a reasonable interpretation of its own regulation, that interpretation is entitled to some deference. Do you agree with what I just said or no?
That is the standard of the law, except for that doesn't apply in this case. And this is the reason why. The defendants themselves, the Department of Corrections, when it comes to interpretation of the words nudity and sexually explicit, or let's stick to nudity at this point, they said that they didn't train their officers on the application or the interpretation to be given. So they left it up to each individual officer to determine, which is in the record, which they all said, to determine, as they wanted to determine what nudity was. This is why I asked the court in my brief is to interpret nudity for the Department of Corrections. Because where they don't clarify that and they leave it up to each individual, they're not entitled to deference.
Is nudity defined in the regulation?
It is.
And are you contending that, are you arguing that the definition of nudity is clear or ambiguous?
Well, it's a double thing at this point, because if you're going by their interpretation of nudity, which is including covered areolas, covered nipples, covered any female intimate body parts that are covered, is considered a nudity under their interpretation.
How about before, I'm sorry to interrupt you, but before we get to their interpretation, just looking at the regulation itself, are you claiming that the regulation is clear and unambiguous, or are you claiming that the regulation itself is ambiguous?
Well, the regulation, as I understand it, if you're applying the ordinary meaning of the words to the regulation, then it's fine. However, if the court accepts their interpretation, then it isn't fine, because their interpretation covers everything that's any part of the body that's visible is considered nudity. If you look at their definitions of, for instance, their interrogatories, they say that all the photographs which you've seen are sexually explicit and full nudity. They are not. But that's their interpretation of that definition, which they're giving the definition of nudity. And if you're using that interpretation, then we have a problem, because it's unconstitutional. It becomes vague and it becomes very broad. So if you're going to use it, just depends on, and this is where I'm at with the court, and this is why I asked the court to define nudity. If you define nudity clear and concise by its ordinary meaning, then they're wrong.
I think your point is well taken, but what about the part of the regulation that states in describing nudity? I think I'm quoting from it, says, quote, as a whole or in significant part, end quote. What do we make of that language?
As a whole or a significant part. Well, again, this regulation is I don't know, I don't think the court understands the history of this regulation. This regulation came into effect after the Ensign Amendment. This regulation is adopted from the federal regulation where they cut and chopped and took pieces out of it. There's actual pieces missing out of this regulation where they originally got it from. So this is like a slice and dice regulation. That's why there's words missing out of the actual regulation. So it's a slice and dice, and it's left, as they always say to us, it's left to their interpretation of the regulation. And as a whole, if the word nudity is given its ordinary meaning, then the photographs are not nudity. It's the photographs are only nudity under their meaning, that they're claiming that anything that's visible makes the photographs nudity.
Mr. Wright.
Mr. Wright, no, go ahead.
Don't we have to give nudity the definition it's given in the regulation?
If you give it the definition in the regulation, whose interpretation are you going to apply to it? Because this is where our problem lies right now, is the interpretation of that word as it is right now in that regulation. Their interpretation is, as we've said, any female body part that's covered and not visible, if the arms, any part of the upper breast, any part of the chest, the stomach, the legs are visible, it's nudity under the DOC's interpretation right now. So it comes up to each individual administrator or mailroom officer to determine whether they're going to contraband it or not. So which then, that brings in that Dana versus United States, doctrine of vagueness if you're using that interpretation. Because then the regulation must require, if you're going to use their interpretation, the regulation has to specify to tell me and anybody sending me photographs the amount of skin that can be shown.
Well, Mr. Wright, I'm not going to rely on what the DOC says, but all of these pictures that I've seen do show either buttocks or female breasts. And that's what the definition of regulation says. So why doesn't it fall under nudity as defined in the regulation?
Okay, so if you're going to use any portion of the breast, that means anybody that's wearing a halter top or a bra, because some portion of the breast is going to be showing from the top, anybody in the swimsuit, they're all not excluded. That goes beyond what the regulation was established for. The regulation was established to knock out pornography within the prison system.
But
You
Mr.
read,
Wright, just,
Moses,
I'm sorry to interrupt you, but to your point on that, does the regulation not also require that the exclude or the prohibition on nudity is nudity by which by its nature or content poses a threat to the security, good order, or discipline of the institution, not just any person in a swimsuit necessarily? Would you agree with me on that?
yes, and if you go to Moses versus Dennehy, that was dealt with that court. That's where the nudity, and this nudity, again, under the definition, is whether what's being shown is, what's being declared nudity in the photographs. If it's some portion of the breast being shown, like the upper portion with the cleavage, if you read nudity according to the way that they're interpreted, that's excluded. If any parts of the buttocks, which is basically all swimsuits nowadays, going to see some portion of the buttocks, because that's the way swimsuits are cut. You're excluding every photograph, every book, every magazine that comes in that has that in it. And that's not the definition of nudity, and that's not the purpose of which nudity was made for in a prison context. It was to prevent them from having those pictures that they claimed to arouse the inmates up and cause them to have deviant behavior, according to the DOC. That's, again, if you go to Moses versus Dennehy. Again, the word nudity, if it's given its plain and ordinary meaning in its definition, those photographs would not be declared nudity. They would not be excluded.
If we disagreed with you, Mr. Wright, on that particular point, would we be wrong to say that the DOC could have chosen to preclude complete exposure, total nudity, or nakedness, rather than defining nudity the way that they did?
Well, yeah, Your Honor, it's you know, one of the arguments I made to you, if you look up the definition of nudity into the regulation, you know, it says a pictorial where genital, buttocks, or female breasts are exposed. Publications containing nudity illustrative of medical, educational, and anthropological content may be excluded from this definition. If you read the second portion of that paragraph, which is, we're allowed to have nudity if it's medical, educational, anthropological. That's full nudity. That would, you know, that when you look at that compared to the first line, it makes the definition of nudity in the top not be what they're making it out to be. It has to be nudity, which is the exposure of female breasts, including the areola, the nipple, or the female genitalia, or the complete buttocks, or the cleft of the buttocks. I don't see how you can separate that second sentence of that paragraph from the first. You have to look at the first and then apply the second to it. If there would be no reason to say that we could have nudity under medical, educational, anthropological if nudity included what they're claiming it does. Otherwise, it would automatically be excluded. You wouldn't have to make that second sentence in that paragraph for nudity, to define nudity. That tells you that the first part of nudity has to be what they said, the exposure of areolas, nipples, female genitalia, the buttocks, or full buttocks, or the cleft of the buttocks, or the anus. And I think if you look to the words, you have to look to the words of the regulation and look at the words that follow the term of what pictorials are supposed to be. Because even if that regulation with the pictorials, that actually referred to magazines in the original regulations, and they just took that part of that out and they just made it across the board. But
Mr. Wright, let me interrupt you. You have a minute and a half left, and Justice Ditkoff has a question for you.
all right.
I just want to confirm that it's your position that the pictures that you're not being allowed to have do not pose a threat to the security, good order, and discipline.
It does not. They do not. And the defendants haven't claimed that they do. Not once have they claimed, because they're non-nude, they're non-sexually explicit. They have not offered any evidence whatsoever that those pictures had an impact on the institution in any kind of way. On whether security,
Mr. Wright, I have,
good order, or
excuse me.
rehabilitation.
I have one final question for you. It seems to me that your argument in part is that nudity says, the definition of nudity speaks to genitalia, buttocks, or female breasts exposed. It doesn't say partial exposure.
Yeah.
It seems that the Department of Correction, on the other hand, is saying, well, it doesn't say must be fully exposed. So I go back to my initial question. Would that or would that not reveal an ambiguity in the regulation itself?
Well, except yes, that would. And that's where Greater versus City of Rockford would come in, because then under that interpretation, that analogy, then it becomes, it's not giving us proper warning of what we can have and what we can't have. It's not telling the people who are sending the pictures what they can send and what they can't send. They're not telling what's going to be excluded and what's not. If you're just going to make it a broad term like that, as the Department of Corrections is doing.
Understood. And your time is up, Mr. Wright. We appreciate your argument. Thank you very much.
Thank you very much for hearing me.
Welcome. And we will now hear from counsel for the appellee.
Yes, good morning, Your Honors. Heidi Handler for the appellees in this matter, and I would suggest that there is no reason to overturn the Superior Court's well-reasoned, thoughtful decision. There are several matters. First of all, one of the clearest matters is on the question of qualified immunity, in that this plaintiff had very similar pictures that were disallowed following a summary judgment motion. And in fact, the matter went to the appeals court. And in that case, the appeals court reviewed the matter. Your Honors had indicated that although the plaintiff was not timely, and that docket number is 19P1573, they concluded that plaintiff has failed to demonstrate that he had a meritorious appellate issue or issue worthy of consideration by the appeals court. So with regard to qualified immunity, you asked our strongest arguments first. There is no way that defendants in this matter could have any way reasonably believe that they were violating plaintiff's constitutional rights if in fact very similar pictures had been excluded and been upheld by the appeals court.
Counsel, that gets you out of the money damages.
Yeah,
But
you asked me to address the strongest points first. That was my last argument, but.
Right. I mean, but we also have his request for, he calls it temporary restraining order, but an injunction. Could you address why he's not entitled to that?
Yes, Your Honors. First of all, this is not a new regulation. The wording in this regulation has previously been upheld by federal courts, Jocelyn v. Dennehy, Moses v. Dennehy, on a facial challenge to the constitutionality of the regulation. Applying the Turner standard, the court found that this was in fact reasonably related to legitimate security interests. Mr. Wright has indicated there is no evidence in the record with regard to those security interests, and that is because the court in that case said that the Commonwealth was not required to prove the legitimate security interests, that in fact, they could take judicial notice that nudity and sexually explicit material did in fact create a security issue within the department's institutions.
So, I mean, I don't know exactly how judicial notice works in federal court, but how can we take judicial notice of what causes security risks in Massachusetts prisons?
I would suggest that I can elaborate on those issues, Your Honor, that the introduction of sexually explicit or nude photos creates a security risk because it creates a situation that may lead to violence among inmates. Inmates could try to steal pictures. Inmates could make comments about pictures.
Counsel, that's probably right, but I didn't see an affidavit or anything in your summary judgment record saying that. Did I miss it?
You did not miss it, Your Honor. The Commonwealth did not provide that because the Commonwealth's or the defendant's position in this case is that based upon the fact that this regulation has been previously upheld and courts have taken judicial notice of it, the fact that the regulation itself states that nudity or sexually explicit material creates a security that may affect the security of the institution.
Where does it say that?
If you look at section 13, 481, 13J, G, excuse me, it states the correspondent contains sexually explicit material or material which features nudity, which by its nature or content poses a threat to security, good order, or discipline of the institution.
Well, so I read that as saying that what's forbidden is correspondence where it has nudity, the kind of nudity which by its nature or content poses a threat to security, good order, or discipline of the institution. Not that it was saying that that automatically poses a threat to security, good order, and discipline of the institution. Why is your reading the better reading?
My reading, Your Honor, references the actual definitions contained in the regulation, that nudity as defined in the regulation and sexually explicit material as defined in the regulation do in fact create a security concern.
Well, the definition doesn't say that.
No, but the definition, I disagree with Mr. Wright that the nudity as defined covers an arm or any or a leg or anything of that nature. I would suggest that the definition, which again has been upheld previously by the federal courts, deals with genitalia, buttocks, or female breasts being exposed. And it is a much smaller definition of nudity. And as the Superior Court, and it also allows the regulation, Your Honor, as I believe Justice Ditkoff pointed out, and not Justice Ditkoff, Justice Heyman pointed out, the regulation allows the department officials to deem something contraband if it is in whole or in part falls within those definitions. And that the case law is quite clear that deference for the internal administration of prisons should be left to department officials who are much more familiar with that, and the court should not be second guessing absent evidence of an arbitrary or capricious decision. And in this case, the lower court reviewed the photographs, and not only did they agree with Deputy Phelps's determination, but they also explicitly made a factual finding that there was no evidence of arbitrary or capriciousness in terms of the finding and determination, and that Deputy Phelps, who was the individual who made the determination, who had, by the way, many years of experience at Sousa Baranowski, at other institutions and that is in the record, his experience with his affidavit, he determined that these were in fact sexually explicit and nude based on his review of the photographs. He personally reviewed all 69 photographs and he rendered that decision. And there's a factual finding that the decision was based on nothing other than a good faith application of the regulations to the photographs.
It seemed to me, and maybe I'm misreading it, that Phelps, all he did was determine that it was nudity. And he did not determine that the pictures by their nature or content posed a threat to the security, good order, or discipline of the institution. Am I misreading that?
I'm not sure where you are reading from, Your Honor, but I would suggest that the contraband notice that was issued to Mr. Wright cites to the 13G, which I have just referred the court, and that in fact, that is inclusive of the determination, as I have previously stated, that by their nature, they did pose a threat to security.
Attorney Handler, I have a different question. I want to go back to the definition of nudity in the regulation. And my question for you is, why is it not ambiguous when it says it speaks to genitalia, buttocks, or female breasts of being exposed? It doesn't say the entirety of any. It doesn't say only, partial nudity. So why is there not an ambiguity in that definition?
I would suggest there is not an ambiguity in that definition because, as Your Honor is aware, regulations should be given their plain and ordinary meaning. And in this case, agencies should be entitled deference in interpreting their own regulations, so long as that interpretation is reasonable. In this case, the department has indicated that it interprets that regulation in whole or in part if it includes sexually explicit, or the nudity definition, if it includes genitalia, buttocks, or female breasts. That is entirely reasonable in terms of, as Judge Gordon said, the department could not, with architectural precision, give more of a definition. If the department were to do so, a plaintiff would then say, well, exactly how much of that has to be exposed. This court should not.
Right. So why doesn't that speak to the fact that because it's impossible to define it with that much precision, there is by definition some ambiguity to it? And then when there is ambiguity, my understanding is at that point, deference to your department's interpretation is considerable.
I understand your question, Your Honor. And the department's position is that it is not ambiguous, rather that there is some discretion involved, and that there is case law that suggests, and I agree with you, that deference should be given to correctional officials to exercise their correctional professional judgment in these matters. And this
I'm not sure that
should-
discretion has anything to do, though, with whether or not something either is ambiguous or it's not. Discretion is a different issue in my view. Am I conflating the two?
I don't believe you are conflating the two. I would suggest that the definition of, is it exposed, what Your Honor is saying is ambiguous?
Well, I get to ask the questions of you, but since you asked.
No, is that your question to me? I'm asking.
I am saying that it is ambiguous because it doesn't say fully exposed. It doesn't say partially exposed. It doesn't define. So I think that's pretty clear.
Yes, Your Honor, I would suggest that those words are
And in
not.
fact, going further, and I'm sorry to interrupt you, but I believe you make the argument at some point in your brief that the definition of nudity does not say it must be fully exposed. And Mr. Wright argues in his brief, to the contrary, it doesn't say partial nudity, or doesn't say may only be partially exposed. So again, I think you've both hit on two different interpretations of the same language, and thus perhaps identified an inherent ambiguity in the language. So that's why I'm pressing the question.
Right.
I hope that answers the question.
Yes, thank you, Your Honor. And I would suggest that the case law, Papacristo and Tsitsi, suggest that this court should not attempt to read in any words that are not there, and the department did not put completely into the regulation. And therefore, exposed is not ambiguous. It does not require it to be completely exposed. There have been several cases. I would suggest the Graziano case and the Robertson case and other cases where there is a question of what is exposed, and deference can be given in this case to the department's interpretation that exposure does not have to be entirely exposed.
Did any of those cases state that the regulation was unambiguous? Did they draw that conclusion?
I believe that I cannot answer that question right now, Your Honor. I can state that this regulation has been previously upheld by the federal courts, and they found that it was not vague or overbroad, and that in fact, semi-nude material was encompassed by this. That's the Gaskins case, Your Honor, that it did in previous cases have found that semi-nude did fall within this definition. So with regard to the issue of fair notice, going back to Mr. Wright, there is ample case law that semi-nude photographs do fall under this definition.
And you have 30 seconds left. Would you like to sum up?
Yes, again, that I would suggest that this regulation is not void for vagueness, that it should be given its plain and ordinary meaning. And the Superior Court and Deputy Phelps both reviewed these, and within the plain and ordinary meaning determined that they did meet the definition of nudity. There is no question that breast with, I finished my time, so.
Okay, I'll give you 10 seconds to finish your last thought.
Okay, again, there is no evidence that there was an arbitrary or capricious determination, only that the regulations were applied in good faith based upon the meaning, and the regulations as written are not unconstitutionally vague, and they do encompass semi-nudity.
Thank you. And Justice Ditkoff, Justice Hand, any further questions?
No, thank you.
Seeing none, thank you very much.
Okay, we are live and on the record.
Calling our next case on the list, docket 2020 P516, TM versus JPK. I will remind counsel that this case is impounded. We will hear first from counsel for the appellant, Attorney Dorman.
Good morning, members of the panel. May it please the court, my name is Deborah M. Dorman, and I represent TM in this appeal. The lower court erred in this case in 3 significant ways. Number 1, the lower court erred in failing to consider evidence of JK's domestic abuse toward TM as a factor contrary to the best interests of the children prior to awarding him sole legal and physical custody of the children. And the lower court order granting JK physical and legal custody sole should be reversed.
Attorney
Number
Dorman,
2.
I'm sorry to interrupt you, but I just have one preliminary question.
Sure.
It is not part of the record, so I want to be careful with this question, but I just want to make sure that the arguments before us are not moot. This is just a yes or no question. Has the state of custody changed since this appeal was filed?
It has not, Your Honor.
Okay, thank you. I apologize for interrupting. Please continue.
Sure. Number 2,
Well,
the lower court erred.
let's talk about number 1 first.
All right.
The judge found that your client's accusations against the father were all false, and all the boys say it's your client and not the father who is abusive. So what more did the judge need to do under those circumstances?
Well, under those circumstances, Your Honor, there were 3 times that my client had come before the court with accusations of domestic abuse against father prior to the children making these statements. Prior to the divorce, mother, may I call her mother? Mother had come before the court prior to the divorce. She had filed for divorce, and before the divorce nisi took place, she came and filed a complaint for modification alleging abuse. The divorce nisi was suspended. An attorney was appointed for the children. A GAL report was filed, and the GAL report clearly said mother should have custody of LK, the daughter in this case, that father needed a neuropsychological exam, and that there was evidence of abuse, of a psychologically debilitating abuse. That is in the GAL report. Nothing was done. Nothing was written in the order about it. The next thing that happened, the divorce nisi, the order suspending it was lifted, and things went on as normal. Mother came back before the court 3 months later, alleging abuse, saying that father continued to be abusive and asking the court to please get him some help. That is our error number 2, that when mother filed this second complaint, this goes again to the abuse, that the court waited 3 years.
Well, Kath, let me ask you about that. As far as I read the record, 9 days after the modification complaint of March 30th, 2016, your client asked not to have the motion heard. And I didn't see any point where she asked for that motion to be heard. So am I missing a place where she asked that March 30th, 2016 motion be heard?
Well, what we're missing, Your Honor, is that the judge then submitted a judgment saying that a hearing was held, and that at this hearing, no evidence, I'm arguing, was submitted about the abuse. We bring this up because there is a judgment that says following the hearing, and it just says dismiss. There was no hearing. The complaint was addressed. The complaint alleged abuse. That's not written in the findings.
Attorney Berman, I'm sorry to
Yes.
interrupt you, but was that judgment that you're talking about that referenced the hearing issued after the trial?
It was, Your Honor. It was
Uh,
issued after. It was, Your Honor.
And
It was
the-
issued. It was
Okay, go
issued on the same day as all of the other judgments in this case.
And
Following
whose
the
burden
trial.
was it on that complaint for modification that you're
I'm-
concerned about?
I'm sorry, I didn't hear the
Who
question.
had the burden of introducing evidence on that particular issue, on that complaint?
On this complaint, the mother had the burden of presenting evidence of that complaint. However, on the judgment, it said after a hearing, there was no hearing, and we're just saying that is another example of where evidence of domestic abuse was not addressed, and that it took 3 years, that there was no evidence, that there was no hearing as is indicated. And that was another opportunity for the court to take some evidence about the abuse. We
Well,
believe that.
That's my question again. When a judge finds that the accusations of abuse are not only false, but are actually made by the abuser, what more does the judge have to do before giving custody to the non-abusive parent?
I did not see where he said they were false. He said that father testified truthfully, but Your Honor, I guess my point is
False.
that false. I guess my point.
Father truthfully testified that they were false, and therefore they're false, right?
All right. So my argument, or the appellate's argument, is the evidence of abuse that was presented was not taken into consideration. That yes, the lower court has an opportunity to decide who they want to believe, but there was additional evidence here, and you're left with the feeling that something wrong was done. As a matter of fact, father's complaint that we're arguing against stemmed from mom's 209A complaint, where she received a stay away order, a no contact order from a different court while she was on vacation with her family. The father then, once served, came into the lower court with a complaint for modification and received custody of the children. Nowhere on that's referred to in the judge's ruling on the 209A that the lower court, revised. Does it say that they considered mom's complaint of domestic abuse? That is our number one argument, that throughout this case, mother was not represented before the divorce. She came before the court before the divorce was complete. That is evidence that should be taken into account when the judge is writing his final orders from custody. It is not just what's been going on after the lower court has acted on dad's orders and interviewed the children with the GAL that says, yes, we live with dad and he's not abusing us. That's not our argument. We're not trying to impeach the credibility of the children. We are saying that mother came before this court, the lower court, 3 separate times with complaints about domestic abuse, and they were never addressed. And a finding that father testified truthfully and the boys said this is not significant enough to devoid mom of her custodial rights. The court did not go far enough. The lower court needed to investigate. My client, to go further, the third complaint, well, my client is an immigrant from South America. English is not her first language. She was a former teacher before this in a school system where English as a second language was the issue. And she shouldn't be faulted because prior to the divorce, she wasn't strong enough in her presentation. And because when the complaint was filed, she took it off the docket. The lower court never considered the evidence of abuse. And
Let me interrupt, Attorney Dorman, let me interrupt you. You said, I'm not sure I agree with the way you've articulated it. I have to give it some more thought, but
okay.
you said that the judge had an obligation to investigate. He certainly had an obligation to consider the issue.
Yes.
But even if he did, am I correct that there were 2 different GALs appointed during this case?
You are correct.
I'm sorry to interrupt, but my understanding is that the second GAL reviewed at least 5 either police reports or investigative reports relating to allegations of domestic violence and concluded, and I think I'm quoting correctly, this is the second GAL said, in spite of mother's allegations of domestic violence during the marriage by father against her and her children, neither her family nor any agency, including DCF or law enforcement, has a record of any reports in which both father and the children deny. Is that correct?
That is correct. That is correct from the GAL report.
Doesn't that show that the judge did, at least in part, investigate the issue through the GAL? The GAL reported back, and based on the GAL report and the other evidence before the judge, there were determinations of credibility made. Why doesn't that speak to appropriate consideration of the issue of domestic violence?
Because the other GAL report, there were 2. The first GAL report says, far from being supportive and caring, father was abusive, that it was abuse of a mental and psychological sort, and that the custody of the youngest child should go to mother. The GAL report goes further, the first one, and talks about how the GAL thought that father had the control over the kids, especially number one, and that his opinion was paramount in how these kids felt. You are correct when you say investigate, and I misspoke, but the lower court.
Well, I understand your meaning, though, and I understand
Should
what
have-
they
should have
certainly have an
considered it.
obligation to address the issue.
That it should have considered it, that while you're judging the credibility of witnesses, it is also important to look at the evidence that happened before the marriage. There are 2 GAL reports, and they are conflicting, although the second GAL report does say that this is a family that's torn apart, and it's because mother is not involved. Mother
Attorney Dorman, I'm sorry to interrupt you, but am I correct that only the second GAL report was admitted at the trial?
No,
Were both?
they were both. As a matter of fact, the judge, during the trial, the judge at T-289 took judicial notice of the entire file. And that was during a debate about the GAL reports, which ones would be submitted. The first GAL report was investigating abuse prior to the divorce. Because as I said, although
Right.
there was a divorce, it was stayed by the judge, by the lower court at that time to bring in a GAL. The GAL made recommendations. Mothers should get custody. Fathers should get counseling. None of that was done. None of that was done. I argue the abuse continued of a psychological and emotional debilitating way, and as was reported by the GAL.
Attorney Dorman, I have to interrupt you because you have 20 seconds left, and I have one more question for you. Your last argument, you state that the court erred in determining that mother did not seek to expand her parenting time with the children. And you point to several instances in the record where she did. My question for you is, assuming we agree with you, what is the correct remedy? Your time has expired, but please answer that question.
The correct remedy is that the judgment should be reversed. The opposing side argues that this was not prejudicial, but in a case that was so focused in on mother and her parenting and her custodial rights, she came before the court 4 separate times. She argued at the court. And I believe that this error was prejudicial. To say that for 2 years, mother did nothing to change her custody.
It would be for, I'm sorry to interrupt, but it would be for a reverse and a remand to the judge to reconsider the calculus correctly, is what you're saying. Is that correct?
We'd like for it to be reversed. We'd like for it to be reversed because we feel that the judge in the testimony said, I need to hear from mother. I must hear from mother. That's in the transcript. I must hear from mother. I need to hear from mother. Mother testified. Mother testified that she had tried to see her children. This is a mother who went from having 50% custody, seeing her children daily, to relegated to 2-hour weekly visits Friday. So I believe that was paramount. It was prejudicial to say that a mother who was fighting for custodial rights did not even try to change it in 2 years. I think that changed the pendulum against her. And
Thank you, Attorney Dorman.
if I'm through, can I just say, as to the other issues not touched upon in my argument, my TM relies upon the arguments in the brief.
And Justice Neyman, may I ask one quick question?
Yep, Justice Hand has further questions. Absolutely.
Can I just ask, counsel, are you appealing the order vacating the stay of divorce NISI, the 12-1 order? I wasn't clear from your reply.
No, I am not. I am just using that as an example of abuse that happened prior to the marriage.
Okay, thank you.
I'm sorry, prior to the divorce.
Gotcha. Thanks.
Thank you, Attorney Dorman.
Thank you very much.
We will now hear from counsel for the appellee, Attorney Jackson.
Good morning, Your Honors. I am Linda Jackson, and I represent the appellee JK in this matter, together with my co-counsel Peter Cooperstein. I was trial counsel. We're asking that this court affirm the lower court's judgment. The judge did not abuse his discretion in this case when he found that a material change in circumstances existed, and that change or changes warranted a change in custody to father, and that the mother be granted parenting time on Fridays at the library. The judge made 124 findings, and those findings were supported by the evidence in this case.
Well, would you agree that his finding that, to the effect that mother has not asked the court to expand her parenting time with the children since the commencement of this matter in August 2017, a period of nearly 2 years, and that's at Record Appendix Volume 4, page 19. Would you agree that that finding was incorrect?
I would agree that that finding was incorrect. I would agree that that finding, I would state that that was a harmless error. And the mother requested that her parenting time be expanded in November of 2017, that at that time, mother entered into a stipulation by agreement, and that is the parenting plan that exists today, and that the lower court entered as a judgment. The only other time mother requested to expand her parenting time was the first day of trial, and that request was denied. The custody judgment was based.
I mean, isn't that an important consideration for the judge? I mean, part of his findings, part of his conclusion rather, is predicated on the notion that, look, mother is either content with the arrangement or mother, isn't doing what we'd expect, i.e. seeking more time, trying to get more time with her children, trying to seek custody. And he was dead wrong on that finding. Why is that harmless? Why doesn't that require at least a remand for the judge to consider the calculus using correct underlying facts?
The court made findings that the children were unsafe in mother's care. The court made findings that the guardian ad litem found that the mother did not act in the children's best interest. The court made findings that the children did not want their younger sibling to be with mother unsupervised. The court found that it was mother that engaged in abusive behavior, and that 2 of the children reported that not only did the mother not abuse father, but the mother had abused them. And the mother agreed to that parenting schedule, Your Honor. It wasn't that there was a temporary order hearing on November 2017 and mother went forward with an argument that she wanted something in addition to 1 2-hour visit on Fridays at the library. I mean, during this period of time, the children were appointed our counsel as well. And our counsel was very diligent in her representation of all 4 children's position, and did not support any parenting time other than what the judge entered in his judgment in this matter. The custody judgment was based on the appropriate factors. The court considered all the relevant factors, the touchstone inquiry as to what is in the children's best interest in regards to a parenting plan. The court looked at whether one or both parents had the ability to subordinate their own needs to the children's needs, whether the parties had the ability to cooperate and work together. And in this case, in accordance with the statute, did take into consideration the factor and the allegations as to whether there was past and or present abuse. Specifically, the court found the father supported the children's relationship with the mother. The father gave additional parenting time during holidays, invited the mother to a child's birthday, brought the children off the island to mother's extended family during a holiday period. The court also found that mother's actions were not in the best interest of the children and were also harmful to them. There was sensitive information shared with one of the children, and also she violated a court order with information in writing via an email to the children and copied it to the father, where she discussed the pending court proceeding in detail. This is a mother who was notified of an emergency order from the probate and family court, and that father was granted custody of the children and refused to return the youngest child for a period of 5 days. This is the mother that made a number of allegations that the father had abused or neglected the children. She called the police department on 5 occasions, and that detective testified at trial. In addition to the guardian ad litem's investigation, those police reports were admitted. Not one of those allegations was founded or substantiated. She disrupted the household. The children were present, and that drove a further wedge between she and her children. And the court found, and the children reported that they were afraid of her. And one child reported that she was making false allegations and that nothing had occurred. Then she made an allegation that the oldest child had assaulted her. That prompted a police investigation. That prompted the detective to go to the home and speak with that child. And that resulted in no criminal charges, and no allegations were unfounded.
Counselor, what if anything, do we make of the fact that the pre-divorce and the post-divorce GAL reports seem to come from different universes?
Well, the pre-divorce report was in 2014. That proceeding ended in an agreement where the parties agreed to share physical custody. The mother had the opportunity to call both guardian ad litems at the time of trial, where those concerns and issues could have been cross-examined, and she chose not to do that. The court did consider the domestic abuse as required. The court considered mother's allegations. The court found that JK denied physical abuse except by the mother in the past. Both of the twins reported that there had never been any physical abuse by father, but that mother had physically abused them. MK informed the guardian ad litem, contrary to what the mother reported, father abused her. That father abused her, it was actually the other way around. That was the oldest child. The court found that the children were traumatized by mother's behavior and that all of her allegations were false. The mother gave false testimony at trial. The mother gave false testimony about her psychiatric diagnoses. The mother gave false testimony about her prescription medications. The court, on its own accord, asked subsequent questions and gave the mother every opportunity to give correct testimony, and she continued to give false testimony. The mother's psychiatrist was called at trial and was cross-examined as well. And that substantiated the court's finding that mother's testimony in regards to those issues were false. When mother was asked about what she had shared with one child that is sensitive information, her response was that she did not recall. The court found that mother's testimony was not credible. The mother created a narrative in this case that just was not supported by any witness or any piece of evidence. The guardian ad litem did an extensive job. She came back to the court on 2 occasions for additional time. She investigated every one of mother's allegations, and she went directly to the source, whether it was the school, whether it was the law enforcement, whether it was the children. She met with 4 children together, individually, on Martha's Vineyard in their home at father's, and off island at her office. The mother's testimony, the mother's narrative and position was just not true. The court did not err in issuing a November 2019 judgment on the mother's March 2016 modification action. The court did everything possible to address all of mother's allegations, and appointing our counsel, appointing a guardian ad litem. Also, mother had 3 attorneys, and mother herself requested a continuance. And
I'm sorry, could I interrupt you, Attorney Jackson? A little bit different topic than what you're on at the moment, but on the topic of mother's requests. What do you say to the mother's or is there anything we should take away from the mother's argument that she made requests for copies of her file that the court failed to provide to her?
Yes, Your Honor, I was present at that motion. So mother at all times had access to her file. The issue was making copies of the file because the court already had concerns that mother was disseminating extremely sensitive and impounded information to the children. For example, there is an email that you go to the children that's part of your record. I believe it was in March in 2018, and that was presented to the court by counsel at that motion. And the court had already heard from child's counsel as well in regards to other sensitive information that was believed or father's position was that was shared with the oldest child. So the court was protecting the best interests of the children in that instance. The mother had access to her file the entire time. She had all of the pleadings from prior counsel, which was her second attorney. And during that 9-month period, there were a few continuances and one pretrial conference. And that counsel, myself and child's counsel, forwarded to mother those pretrial conference reports. So there wasn't any document that the mother did not have in hand that was filed with the court during that period. And also she had access to read anything that she wanted.
And to the mother's point about the failure to, or the mother's position that the judge failed to hold a hearing and yet said that the judge held a hearing on the mother's request or complaint for modification. What do you say to that?
I'm sorry, Your Honor, I didn't understand the question.
The mother, sorry, probably poorly phrased. So the mother contends that she filed a motion and a complaint for contempt together. At one point, she withdrew the motion, and the complaint for contempt, as I understand the mother's argument, wasn't acted on until after trial, whereupon the judge said a hearing was held. The mother contends no hearing was held and that no evidence was taken with respect to the mother's complaint.
My recollection is that the complaint for contempt at the time of trial involving allegations that there were financial matters that weren't settled, that my sister at the time withdrew that complaint for contempt. That was my recollection, and that subsequent the court did make findings that there wasn't any evidence at the time of trial on that issue as well. So mother's fundamental rights to due process were not violated in regards to the denial only to make copies of her file. And that order was necessary to protect the best interests of the children in this case due to the sensitive nature of the impounded information. And just in regards to the court's incorrect finding that the mother had not requested an expansion of her parenting time since I think May of 2017. I just think the touchstone of the judgment was not finding that the mother did not request the court to expand parenting time. It wasn't the basis of the court's findings and judgment in this case, and therefore I'd submit that that was harmless error. In conclusion, we're asking that the court affirm the lower court's judgment and award the father appellate counsel fees. Thank you, Your Honors.
Thank you. Thank you, Attorney Jackson, Attorney Dorman, both parties very well represented.
We are live and on the record.
Calling our next case, docket 2021 P556, Department of Children and Families and another versus mother and another. We will hear first from counsel for the appellant.
Thank you, Your Honor. Good morning, Your Honors. Richard Shokire for the appellate mother. May it please the court. Mother has raised 3 issues on appeal. However, given the nature of my brief and its preface under Commonwealth v. Moffitt and Care Protection of Valerie, it is my position that I am constrained in my ability to add to any of the arguments. I'm happy to answer any question, but otherwise, I'll rest on the brief.
I just have one question, and that's, do you agree that the judge properly considered and applied the factors under Chapter 210, Section 3 as required?
Yes, Your Honor.
Thank you. Seeing no further questions, we thank you, counsel.
Thank you, Your Honor.
We will now hear from counsel for the appellee.
Good morning, Your Honor. This is again Adam Hornstein on behalf of the Department of Children and Families. In light of appellant's presentation, the department is also happy to rest on the briefs unless the court has any specific questions for the department, or unless the court wishes the department to expand further on the arguments presented in its brief.
I'm afraid you're not going to get off quite that easily, because I do have a concern, which is that the court draws a negative inference against the mother for not attending the hearing, and the particular negative inference is if she had appeared, she would have had no evidence to counter the department's evidence. But the court also finds that it actually is mother's mental health issues that prevented her from entering the courthouse and participating in the trial. So I don't see how those two findings can go together. If it's because of mental health reasons, it's not because she didn't have any evidence. Could you tell me what you think about that and whether it matters?
Yes, Your Honor. I think that is a fair question. And to answer the second question first, does it matter? It's the department's position that no, it does not, because the appellant does not challenge any of the factual findings in the appeal. Importantly for the argument, the ineffective assistance of counsel argument, I'm not sure that minor incongruity makes a difference to the ultimate inquiry, which was ineffective assistance provided. It's the department's position that, one, this argument is not properly before the court because it was not properly presented below as part of a motion for a new trial. But even if it were properly presented, again, where the court made clear that it wasn't going to continue the trial under that mother had requested for any reason, that counsel discharged his obligation by presenting mother's argument and persuading the court to allow mother to participate by telephone or otherwise by Zoom if she wanted to do so. And I'm not sure that this tension that the court identifies makes a difference for appellant's second argument concerning whether or not the department had discharged its obligations to make reasonable efforts to provide services to mother. Again, the department's position is that the court below did not clearly err in reaching that conclusion for the reasons stated in the brief. And again, this incongruity doesn't really go toward that inquiry at all. And the same is true of appellant's third argument concerning disqualification of trial counsel under the rules of ethics. So I'm not sure that that tension that you've identified, Justice Ditkoff, moves the needle with respect to any of those three arguments.
All right, but what do you think about it on its own merits?
On its own merits, again, I don't think the court clearly erred in concluding either that mother did not wish to participate because of her mental health issues, which are discussed in the record, and the court was also well within bounds to draw a negative inference. But even wiping away that negative inference, Your Honor, for the sake of argument, the court's judgment concerning the termination of rights was well within bounds, particularly whereas here appellant does not challenge any factual findings on appeal.
Thank you.
And seeing no further questions, thank you, Attorney Hornstein.
Thank you very much, Your Honors.
Counsel, we hear from Attorney Chenevert.
Good morning, Your Honors.
Morning.
My name's Dana Chenevert, and I represent the child who asked the court to affirm the lower court's decree that frees her for adoption. If the court has no questions for me pertaining to the child or any questions pertaining to the brief, I'd be happy to rest on the brief, as my brothers have.
And seeing no questions, I would just like the record to reflect first that we appreciate the candor of counsel for all parties. That we also appreciate the briefing and the excellent representation by all parties in this matter. And finally, we have reviewed and we will continue to review the extensive record in this case and the judge's comprehensive findings, of course, in full before issuing any decision, making our final determination. 2022 for the Massachusetts Appeals Court. Our next case is docket 2020 P1363 Driggers versus RIZKALLAH. We will hear first from counsel for the appellant, Attorney Grossman.
Good morning, Your Honors, and may it please the court. My name is Emily Grossman, and I represent the appellant, Dr. MOUHAB RIZKALLAH, who is the individual claiming adverse possession to a triangular shape of land, which is the disputed area that is located in Winchester, Massachusetts, at the back corner of two suburban properties. The key question in this case is, what is the adverse possession threshold for a suburban lawn located at the very edge of a suburban forest? And I submit that this question's actually already been answered by this court, and that is in the case of Mancini v. Spectacular. As in that case, this instant case is a situation where the forest edge is clearly distinguishable from the lawn that is integrated into the remainder of the RIZKALLAH property. So I think in this case, it's very helpful to look at some exhibits. I know you may not have them right in front of you, or you may.
Actually, we do.
Okay, great. So starting with Exhibit 67, which is Record Appendix 493. If you take a look at that.
What volume are you on?
Excuse me, volume 1 it would be.
Volume 1, 493 is a transcript.
Hang on one second here.
There's some pictures near the end of that volume. And some pictures at the beginning of the next volume.
Sorry, yes, it's 11. Thank you.
So volume 2, page 11.
Yep.
Got it.
So if you take a look at that picture, where do you think the yard ends? I think anyone looking at this picture would say that the yard ends at the forest. And that's what the Mancini case teaches us, that if there is a clear delineation between a vegetative border and a cleared, maintained area, that signals to any owner of record that that area is being used under a claim of right.
So is the blue house in the background of, the blue house in the background of that picture is 30 Arlington, correct?
Correct. Yep. So to orient you,
and to the left would be 34.
Yep.
And the walkway leads over toward the gravel area, and to, I guess, to the right of that would be where the swing set is or was, correct?
Right. So you can see the little children's yellow toy. That's the beginning of the play area and the swing set area. You see the large flat stone.
This picture was taken after the extensive renovations that the doctor made.
It was, but something key here is that this walkway area is pretty much left untouched. As far as what the area looked like since 1994, which is the testimony from Ronald Nivola, who was the landscaper that installed the whole landscaping system and maintained it. So that middle area there is really untouched. The only difference is that the flat stones were placed there in 2009, where previously it was just grass.
So you mentioned Mr. Nivola, so let me interrupt you right there. And for purposes of the question, of this question, I want you to put aside your argument that the walkway area mandates a finding of adverse possession. I know that's your final argument, but put it aside. To what extent does this case hinge on the judge's findings regarding the operation of the sprinklers and the lights between 2002 and 2006?
Yep, and I anticipated that question would come in. And with that, I mean, all the adverse possession requires is continuous use. It doesn't have to be constant use. And I think that in that period, there's a very clear and reasonable inference that this all existed during that time as it did. Because in 2000, the end of 2002.
But my question isn't, my question presupposes that the judge's findings of fact that we accept them. We may not in this case, and I understand you make an argument that's clearly erroneous and it's a very detailed argument, and we'll get to that. So for purposes of the question, I want you to also assume that we agree or accept the judge's findings of fact. If we do, what happens to your argument?
The only thing,
and I'm not saying that we do, but
sure. And I guess the findings of fact you're referring to, just so I'm clear, are the inoperating sprinklers during the 2002.
Yeah, essentially that the sprinklers and lights were not continuously, he found no continuous operation. So assume that we agree with the judge's, he actually went a little further than that. So assume that we agree with the judge's findings of fact regarding the operation of the sprinklers and the lights between the years 2002 and 2006. What?
I think what you're getting to is whether or not there's sufficient actual use. And the actual use in this case goes beyond the operating sprinklers, because while the judge found that those sprinklers weren't operating between 2002 and 2006, they were still present in the area. And there were plenty of other things present in the area to indicate that this was being used under an act of dominion. That includes the large flat stones, the swaths of grass in between that were mowed and maintained. You've got lights that are still there. I don't believe there was any.
Okay, so your answer is that even if the judge is correct about the non-operation or no proof of operation of the sprinklers and lights between 2002 and 2006, that is not dispositive.
Correct. Yep. And if I may, I don't believe the judge found that the lights were not operating during that time period. He just didn't find Nuvola's testimony credible that he could see them from, he didn't believe that testimony. And Nuvola's testimony, though, regardless of whether he saw them from the road, were that in the fall of 2002, when he closed down the sprinkler system, the lights were working. And when he came back in the spring of 2006, the lights were still working the exact same way that he left them. So it's not dispositive. And I think as far as the sprinkler functioning goes, I think you can take the teachings of the Mancini and Miller case, which says just this plain open flat area, as long as it's mowed and maintained, is sufficient. The sprinklers are just a bonus. There's something on top of that. And they were still physically present along with all of the other acts of dominion. So yes, in short, as you said, not dispositive.
So that, of course, presumes that we find clearly erroneous the judge's finding that you didn't show that it was being mowed.
Correct. And I think that upon a full view of the record, I think the court is going to be satisfied that there was active mowing. I mean, I think that there are clear errors in this case. This case was interrupted by the pandemic. We know the judge.
I had a hard time following your brief, so I'd like to know exactly which factual findings are clear erroneous. I get that the factual finding that the area wasn't mowed, you believe, is clearly erroneous. What else in the factual findings you contend is clearly erroneous?
It's a very interesting question, because when you look at the findings, there really isn't a lot in dispute at all. The only thing that the judge found where incorrectly, as far as the clearly erroneous finding of fact goes, is that he says there was no evidence, credible or otherwise, of any regular mowing in the area. That's incorrect. We have the direct testimony of James Aiken, which is key both to the actually gap between 2002 and 2006, as well as to the mowing. Mr. Aiken owned the property, the Driggers property, in 2005. And he testified that he regularly saw landscapers mowing in that area, and that he recognized that area to be part of the Rizkallah property. But other than the mowing and maintenance, there's really little in dispute. There's no dispute that since 1994, at least, the land was cleared, that it was a flat open area, which is the judge's finding, that there were the sprinklers installed, the lines underneath going through the ground, there was the lighting installs, there's a valve box with big white letters that say West Cumming Park. All of those other features are things that the land court.
So I've got it correctly. I can accept all the factual findings in your view, except for the mowing. Factual
Correct.
findings.
Yep.
Okay.
And I think that the land court's conclusions of law don't support the factual findings that they had. There's a disconnect between the factual findings that the judge made and the conclusions of law that were drawn. A key one being that it treated the land as if it was wild or wooded property. This isn't wild or wooded property. And that's why we've drawn your attention to these key exhibits, because if you look at it, yes, these have the changes that Dr. Rizkallah made in 2009, but it takes no stretch of the imagination to really think of what the property looked like. I mean, that's why the walkway area is very instructive, because it shows us essentially what the area looked like before. It's a grassed area, and that grassed area continued to the back of the property, abutting the Winchester Country Club golf course.
If we don't reverse the finding about the lack of mowing or the lack of proof of mowing, what do you have?
You know, I think that you still can find, and I think you still can reverse. I think that there's one finding in there that the judge makes is the judge finds that there was grass between the stones. The judge later then says there wasn't enough grass, or the grass didn't grow enough to be mowed, but that doesn't mean it wasn't maintained. It doesn't mean that all of those other features were there. And, you know, I do submit that that contradicts the testimony that the lawn was, you know, indistinguishable and integrated from the entire Rizkallah property. But should it be that that grass didn't grow well enough to be mowed, there's still grass in the area and there's still all of these other features. And mowing the grass may not even be needed to maintain its appearance as a suburban backyard corner, if you accept those judges' findings.
Yeah, but you have to have an open and notorious use of it. The mere
Sure.
fact, I mean, so if we don't have mowing, and I understand, I mean, we got to really dig into the transcript and figure out that. But, you know, just for the sake of argument, if we don't find mowing, what have you got for open and notorious use?
You've got the features there. You've got I mean, you basically have everything you had in Mancini. You've got everything you've had in Miller.
In Mancini, we had a paved basketball court and hoop. We had regular mowing and yard maintenance. So we don't have mowing and yard maintenance. We don't have a basketball hoop or court.
Right,
Or hoop. What do we have?
You've got those other acts of dominion of the property that was maintained and seamlessly divided from the rest of the property,
Right.
landscape features, but also you've got the clear delineation. And I think that's a really important key in this case, is that.
Hold on. So your position is a clear delineation, even with no use of the land whatsoever, is enough for adverse possession?
No, I'm not. I'm saying that the delineation in this case is sufficient to signal that that area is being used in that way. And the use part is the maintenance of the area and the landscape features therein. I mean, even if the area is not mowed, you know, you've got operating sprinklers. They're not sprinkling the woods, they're sprinkling the water. You know, you've got operating lights, even if they aren't operating for a certain period. I think the inference is that, you know, I think it's easy to close that gap and assume that, you know, this is an affluent neighborhood. These are people who take care of their property, and sprinkling isn't necessary actually for grass to grow, but they had this. And so I think that the grass was still growing and still maintained and seamlessly with the remainder of the Rizkallah property as if it were theirs.
To just make sure I got it, we've got the mowing, and if we find the mowing, you're saying under Mancini that's enough, and even without the mowing, you've got the sprinklers and lights. We would just have to determine whether we disagree with the judge on whether those were open notorious, but you were saying they are, in light of the suburban nature. Have I got that right?
Yeah. Yes, but it's not just the lights and sprinklers. Remember, there's that obvious boundary log. There are the stones. There is a mulch bed on the back that accumulates in a peninsula that has plants, you know, ornamental plants in it. There's, again, that valve box with the words on it. There's a lot of other things here. I think the court was pretty narrow in just focusing on, the lights or the sprinklers or things in isolation rather than the totality of their use. And I think looking at the full record and the totality of the use over the 20-year period, I think that, I submit that that is sufficient under the standing case law in this state, particularly those 2019 decisions in Miller and Mancini, that this is sufficient to establish adverse possession. So with that, I refer you to our brief for more detail. I know I've got a little time left if there's any more questions.
Seeing none from the panel, would you like to conclude or would you like to submit on brief? Or it's up to you.
I think that's it. I think one thing to keep in mind is that this case was interrupted by the pandemic. I think that may have been what caused some of these mistakes, is a misremembering. That's hard. We were all disjointed at that time, and this case really fell in the middle of it. We ended in January, the trial, but then all of the closing arguments and everything, happened months later. And so I think there is some integrity of the testimony that got lost here. And so on that, I will submit to my brief, and I thank you for your time.
Thank you, Attorney Grossman. And we will now hear from Attorney Johnson. Counsel.
Good morning, Your Honor. Just want to make sure you can hear me. That's one thing I've learned to ask on a Zoom meeting.
Thank you. Yes, we could hear you perfectly.
Okay, thank you. It's nice to have a meeting that no one says, I can't hear you. I appreciate the court scheduling this hearing through Zoom. This is really a case in which the defendant just doesn't like the findings made by the trial judge. I have no doubt that if the defendant wrote the decision himself, it would be different. But the trial judge made extensive findings of fact. And not only did the trial judge make extensive findings of fact, but he pointed to the record in the footnotes. I think there are over 80 references to exhibits and to the trial transcript. It's not a case in which there was a lack of memory by the trial judge when he wrote the decision. The court had the transcript. It's the same transcript that's before you. And the decision is a well-reasoned decision. Not only did the judge cite to the basis for specific facts, if he didn't credit certain testimony as being credible, he stated in detail why he didn't believe it was credible.
Well, didn't the judge use the words, and maybe I'm paraphrasing, but there was no evidence of mowing?
He did. The judge found, and I think specifically,
is that erroneous? Shouldn't the finding have been, if that's what he intended, that he doesn't credit the evidence of mowing?
The judge stated, and it's on page 11 of his decision, further testimony that the areas maintained was not based on personal observation of maintenance. The judge made a finding that there's no personal knowledge testimony as to the maintenance. The judge made further findings as to the condition of the rocks and the stones, and made a further finding that there was no evidence that was introduced as to who installed the stones. Now, keeping in mind that the standard of proof in an adverse possession case is that the party claiming it has the burden of proving each element. And in C. Pine's condominiums, the court stated, if any of the elements remain unproven or left in doubt, the claimant cannot prevail. This is a case in which the judge made specific findings, believed certain witnesses, didn't believe certain witnesses, which is certainly the judge's prerogative. The judge states, that he in the decision as to how he looked at the evidence, stating that based upon the facts stipulated by the parties, the documentary and testimony evidence, my assessment as a trial lack of credibility, he looked at everything he should look at. And further, there were certain agreed facts that were agreed to. It's Exhibit 1 One of them being that that Ron Nivola did not go on to the Ritzkallah property for approximately 5 years. I mean, that was an agreed fact. And you can't just look over a gap of 5 years in a 20-year period. Now, the court can make certain inferences. The court doesn't have to make inferences, but the burden is upon the party claiming adverse possession to cover the entire 20-year period, and to cover the entire 20-year period by evidence that is based on personal knowledge, not based on speculation, and the defendant hasn't done that. As much as a defendant would like the court to find that the trial judge didn't remember certain things or reach certain conclusions, otherwise, that's not the case.
Counsel, is it your position that the judge, considering that that period where Nivola wasn't around, that the judge couldn't infer that things continued happening, or wasn't required to infer it?
I think both, and I think both. And keep in mind, the judge did take a view of the property in November, and could look at the property, and his decision sets forth on the basis of his findings, in this case, that Mr. Nivola could not have seen the lights. And even if he saw lights, he couldn't determine where the lights were coming from, because they're all up lights. And I believe further the testimony was that the lights were to shine onto the trees, which they seem to be now claiming that there weren't any trees, it wasn't wooded. But that was the testimony, was that the lights were on trees. There were a whole lot of lights in that whole area, and that Mr. Nivola couldn't have made a determination, even if the judge believed that he came by and could actually see what was happening in that area. Further, there was no, Mancini had is not applicable, because the Mancini court said that there was a area, well-defined vegetative boundary. Now, as much as a defendant would like to somehow say that there was a boundary log, the court specifically stated that it wasn't a boundary log. And the court said it was a log that just happened to fall. This is a case in which the defendant had to prove by adverse possession the two areas. One is the area of the triangular area that we've been talking about. And in that area, the court found that there was a gap of the 5-year period, found that there was no evidence as to who installed the stones, and whether or not they were installed by the predecessor entitled to Ritzkallah, and whether or not there was lawn maintenance, which the court found there was not credible testimony of personal knowledge to reach that conclusion. Then you have the retaining wall, and the retaining wall aspect of this, the court found that there was no evidence of any encroachment of anything on Ritzkallah's property onto the Drigger property, and therefore the retaining wall was only used for a period of 9 years since Mr. Ritzkallah took title to the property. And again, that's based upon evidence, which are the two plans submitted by McGowan, prepared by McGowan, one submitted, I believe, to the town, which was a landscape plan and an as-built plan that showed no retaining wall at all going on to what's now the Drigger property. The court made very specific findings on each of this, and the court didn't, when the court didn't credit certain testimony, the court made it clear why. In the case of testimony that somehow there was a retaining wall from the Ritzkallah property onto the Drigger property, prior to when Ritzkallah purchased the property, the court found that the plans prepared and submitted did not show such an encroachment. And I'm not sure if the defendant at this point is still claiming that there was a retaining wall that went from one property to another, but the court was very specific as to their findings and the basis of the findings. And that's certainly consistent. The court certainly was consistent in placing the burden on the defendant in an adverse possession case to meet all of the elements of an adverse possession. Mr. and Mrs. Drigger didn't have to present evidence, though they did, but the court found that the evidence produced by the defendant was insufficient to meet the defendant's burden of showing the elements of adverse possession. And that's a burden that the defendant has. And apart from the gap of 5 years, which is based on the record, there was no evidence as to who put these stones in. There was no direct personal knowledge evidence as to who did the landscaping, how frequent the landscaping was. There are gaps in this 20-year period, and there are gaps in the evidence. And the court did not have to credit certain testimony that it didn't believe was based upon personal knowledge or was contradicted by other documents and by other testimony. That is the role of the trial court when they hear a case and they make specific findings. And in this case, I believe when I last looked, there are about 94 specific findings that the court made reference, and they reference where in the transcript and where in the record each of its findings were based upon. And I believe it's a very well, 93. I believe it's a very well written decision that provides a basis for the court's determination of the various facts. Unless your honors have additional questions, I'm happy to submit on the brief and the argument made this morning.
Justice Hand?
No. Thank you.
Justice Ditkoff? Nope, seeing no further questions, the case is submitted. I'd like to thank counsel for your excellent arguments and your very helpful briefing. It's a very fact-intensive.
We are live and on the record.
Good morning. Calling our next case on the list, docket 2020 P1046, Pareles versus Jacobi and Chamberlain and others. We'll hear first from counsel for the appellant, Attorney Pareles.
Thank you, Your Honor. This case is as important to the court system as it is to me. It's about the administration of justice. I'm taking the directions of Massachusetts General Law 93A very seriously, and I'm acting as a freelance attorney general here. And while I'm certainly seeking money in this case, in many ways, this is not about money, it's about the practice of law. The defendants made me take 8 years to collect a claim for my attorney's fees for collect my claim for $5,806. It was 8 years of opposing counsel, bringing no meritorious claims and just slinging garbage. A brief word about the merits of the case, and then I'll go directly to Judge Cohen's argument. All of the defendants in this case are professional process abusers. I was awarded $10,132.25 on November 7, 2017, after the District Court Appellate Division ordered Framingham District Court to pay me all the interest I was due. I filed for malicious prosecution in Superior Court on March 4th, 2019, well within the 3-year statute of limitations. The tactics used by the defendants are infallible, and they will inevitably win if they're allowed to get away with this type of thing. If it were not for the fact that I were representing myself pro se, my claim would have been crushed in legal fees. These defendants have found a route to victory that obliterates the fact-finding and justice aspects of litigation, and they're well practiced at it. I expect to find in the discovery that the attorneys at Jacobi and Chamberlain made a small fortune by breaking the law. While these are the worst process abusers I've encountered, this conduct is rampant in the trial courts, and it should be dealt with. I'm doing this because I've been an attorney for 33 years, and I'm tired of seeing this kind of conduct. And with my appeal of Judge Cohen's decision, I'm facing down a trial court that really just does not want to hear it. I'm hoping that here in the appeals court, you will encourage me to defend the law. The merits of my case.
Why do you say that? I understand you didn't like the result, but Judge Cohen held a hearing. The transcript reflects a full and fair hearing, that people were given an opportunity to be heard.
It does.
I can't, a transcript isn't a script, so I can't judge tone from that. But I didn't get the sense that she gave you short shrift at the hearing. Why am I mistaken?
No, you're not mistaken. I have no complaint about the hearing. I got a full and fair hearing. It's a simple disagreement about the nature of the law, and that's where it stands. I'm no complaint about the process. This is about the result.
Well, and Judge Cowan also wrote, if I'm not mistaken, her memorandum in order is single space, 7 pages. She addressed each count. Again, I'm not sure. You said a judge that just doesn't want to hear it. That I don't know that the record supports that claim. It may support other claims that you're making, but I don't see how the record supports what you're saying about Justice Cowan or her treatment.
I understood, Your Honor. So I'll face the issue directly.
Well, I'm not, again, that's just what I can only go by what the record says. If you are making an additional claim, we haven't made up our mind about anything, to be very clear. Not a thing.
No additional claim.
I'm just addressing your argument that you just made to us.
I'll tell you where I disagree with the judge and where I think she's incorrect as a matter of law, and that's really all that I'm saying to you. First, she ruled that as you know, a cause of action for malicious prosecution accrues when the matter terminates in my favor. Judge Cowan ruled that the matter did not terminate in my favor. I was awarded $10,132.25. The defendant's counterclaim of $333,000 was denied. So the matter did terminate in my favor.
Let me interrupt you right there. I'm aware that you prevailed and there were counterclaims brought for substantial damages and they didn't get damages, but on the counterclaims, they did prevail on 2 counts, correct? They prevailed in the sense of a verdict, a favorable verdict, correct?
They did, but it still is a judgment in my favor. Were awarded nothing on those verdicts. And you know, the fact I should have attacked those verdicts under Rule 12.
Let's go by what happened, not by what should have been done.
Okay, so, certainly.
What does the case law tell us in a situation like this, where one party prevails on their claim, and by prevail I mean gets a verdict. I'm not talking about damages. Right. And the other party prevails on their counterclaim. Does the case law address a situation like that?
It does. I actually have case law in my brief discussing the fact that I don't have to prevail on every claim to have prevailed. The award of damages in this case is simply enough for me to claim victory in this case. I also want to point out to you that one of the claims they prevailed on was.
I'm not sure I get that, because isn't the malicious prosecution based on the counterclaims? I mean, you can't sue on the grounds that they defended your lawsuit, can you? Or is that what you're suing on?
No, I'm not suing on the grounds that they defended the lawsuit. I'm suing on the grounds that their $333,000 counterclaim was denied. And for example, they want a quantum merit claim. I'm baffled as to how that could possibly occur, since the defendant never performed a service for me. And I should have appealed that as well when I went to the Court of Appeals for the district court.
It wasn't the theory that she had overpaid you for the work you did? That's what it seemed to say from the answer and counterclaim complaint.
If that's the theory, that she overpaid me, the award by the court is a statement that she didn't overpay me. They gave me $10,000. So that's rebutted by the judgment of the district court. I prevailed on my money damages. The other counterclaim, what was breach of contract, which is a little strange, but I can understand why it happened. I argued to the jury I argued to the jury my contract claim and my quantum mirror claim. Jean Lee hired me to harass her ex-husband, and I stated to the jury, I'm a family law attorney. I don't do harassment. So the jury interpreted that as a breach of my contract since she contracted for me to harass her husband. I didn't get to instruct the jury that as a matter of law, you can't contract to do harassment. You can't contract for an illegal act. So while those counterclaims are an interesting artifact of this case, in fact, they're rebutted by the judgment. I was awarded a substantial amount of money.
How do we go beyond the judgment in a malicious? How does the judge go beyond the judgment in a malicious prosecution case? How do you collaterally attack an adverse judgment to you for the purposes of malicious prosecution?
I would say you can't, but I also would say I was awarded a lot of money. It's not a collateral attack. The final judgment of the court was that I was not overpaid because they gave me $10,000. And the final judgment of the court was that I deserved it. And they gave it to me under my quantum merit claim. And I argued under the quantum merit claim because I didn't do what my client hired me to. Well, I didn't know that she was hiring me for harassment. I didn't realize until she retracted her entire story on cross-examination. I didn't realize that my client was lying to me. If I'd known that she was, for example, she denied that she's ever married. The court ruled that she was married. I wasn't aware that she wasn't telling the truth. But in the event of that, I'm still entitled to the quantum merit claim, which I clearly won.
Had you conducted discovery in the underlying case, seeking from the other side any information regarding proof of the existence of the marriage?
In the underlying case in the probate court?
Yes.
Or in this case? I investigated whether the marriage had occurred.
Right. My question to you is, did you seek discovery?
I did seek discovery. I wasn't given any proof of, actually, I was given a proof of the marriage, but it was a forged document. Attorney Keller produced a document that stated that they had no record of the marriage. Well, the fact is they had no record of the marriage because number one, their records don't go back that far. And number two, it's an exhibit to my appeal. In the 1960s, when somebody emigrates from South Korea, they take the marriage records with them. So Jean Lee took the marriage records with her, and that's why they couldn't be found. Jean Lee also had her divorce documents, which her husband didn't have, and I didn't even find that out till after the trial. But I want to comment on that affidavit because it's a forgery. The affidavit has a caption box and a docket number from the probate case. Yet that affidavit is dated a year after the probate case closed. So Attorney Keller was trying to pull off a fraud to convince the jury that this was a document from the probate case that I missed. So there was evidence of that nature. It's just was blatantly false. So another statute of limitations grounds. Attorney JACOBI sent me a letter threatening sanctions and attorney's fees to try and stop me from conducting my appeal in the district court. It was pretty effective. I almost didn't conduct my appeal in the district court, but that letter did cause me emotional distress, and I filed my complaint in Superior Court 3 years later to the date, so within the statute of limitations. So that emotional distress complaint alone should be sufficient to sustain my statute of limitations argument.
Attorney Pareleles, with putting aside the statute of limitations, you take issue with Judge Cowan's determination that the letters that Attorney JACOBI sent didn't rise to the extreme and outrageous levels that are required for 93A. What do you say about that?
Okay, so let me address two things. aside from 93A, I have intentional infliction of emotional distress count. I filed a jury claim. I have a right to have that decided by a jury, not at a Rule 12 motion. And that's not a decision for the judge. 93A, as you know, is a decision for the judge. But even if she were making that decision under 93A, I should have been entitled to argue it at a Rule 56 motion after having conducted discovery. So both of those decisions on that letter were premature.
What's your best case for the proposition that an attorney letter threatening attorney's fees and sanctions if warranted to another attorney can constitute a viable action under Chapter 93A, Section 11? Your best case.
You used the word "if warranted." It wasn't warranted.
Well, that's what the letter said. I'm paraphrasing. What the letter says from Attorney JACOBI is, if you proceed to seek a reconsideration of the judge's order and we are caused to expend time, energy, and effort to appear and contest your motion, we will seek attorney's fees and the court's advice as to any sanctions that would be warranted. So taking that portion of the letter, what is your best case that says that an attorney to attorney letter containing language such as the language I just read may constitute a viable cause of action under Chapter 93A, Section 11, attorney against attorney?
It caused me emotional distress. The actions of the court in overturning the decision proves that it's invalid.
My question is, what is your best case, your best legal authority that the letter sent from JACOBI to you can be the predicate for a cause of action for Chapter 93A, Section 11 claim?
It's a threat. It's a serious threat.
No, I understand. I'm asking for a case.
I don't have a case for you right now.
Okay, thank you. I interrupted you. Go ahead, please.
You also have to take it in context. It's not just one letter. It's one threat after another, after another, after another, after a $333 counterclaim that could have wiped out my life savings when I'm trying to collect $5,806. It doesn't stand alone. It stands in a history of 8 years of abusive tactics. It stands in a history of, Attorney Keller filed a motion to have me drug tested. She accused me, she stated that I was involuntarily committed to a mental hospital, which is a lie. It doesn't stand alone. It's the end of a long history.
Attorney Parole, your time has expired, but if you would like to sum up, we'll certainly give you that opportunity.
Certainly. While the defendant prevailed, I cited case law in my brief. I don't have it directly in front of me, showing that you don't have to prevail on every count to argue that you have prevailed. And nothing's a stronger argument that I prevailed than the fact that I was awarded over $10,000.
Where did you raise that argument below? That it was okay that you had a malicious prosecution claim as long as you prevailed on some of the counts, on the counterclaim counts. I didn't see it, but I might have missed it.
Just a second. Just one more moment. I cited a criminal case in there discussing the fact that the malicious prosecution went forward, even though some of the counts went forward.
Where did you do that?
One more. Here. I believe. I believe it may have. I believe it may have been in my opposition itself. I would direct you there. I also want to add one more thing. The 93A claim. The 93A claim, I'm still entitled to have it decided by a judge after a Rule 56 motion in my discovery. And again, the 93A claim, they all relate back to the claims that go forward. All I need is to have my emotional distress claim, my malicious prosecution claim, or my 93A claim declared valid, and everything relates back to it.
Very good. We saw that argument in your brief. Very good. Thank Attorney Parole. Thank you very much for your argument.
I would like to direct you in one of, I believe it's my opposition. I referred to a criminal case where the malicious prosecution went forward in spite of the fact that they only prevailed on, in fact, in spite of conviction on one of the claims. I'd ask you to look for that.
I assure you we have read your brief. We will take a look again at your brief and the cases in the record.
Thank you, Your Honor.
Very much. Very good. And we will now hear from counsel for the appellee, Attorney Keller.
Thank you. And I would just note that Jean Lee is not here, but she had asked that I also, her arguments be, segued into my arguments as well. To address the issue of the case he raised, just so you can find it for the ease of the court, it's on page 28 of his primary brief. Talk about the malicious prosecution of criminal case. So he did actually discuss that. My position
was that case cited in his papers in the Superior Court?
Actually, it was cited in his appeals court case. I don't believe it was cited in the underlying case. It's on page 28. It's Muniz v. Melman. It's a Massachusetts 1951 case, and it was a subsequent case in 2009. Goddard v. Kelly. Just for the ease of the court. I would argue that doesn't even apply here because the counterclaim for breach of contract, that is what the counterclaim was for, that the damages on the breach of contract was the loss in her value and the equity of her home because now she's determined to be married. I just want to kind of address for the court the frustration we've had in this litigation going through this, beginning actually in Cambridge District Court, where a motion for summary judgment was brought even before this return of service was filed. And then in Superior Court, and I understand my motion to dismiss, one of the arguments was that, he wasn't a member of the bar at the time. And the court did clarify that. And I could have looked up on the Mass Bar Association website to see that he actually had been. That was actually based on apparently a typo in his own complaint saying when he was a member of the bar. And I should have done a second check on that, and I apologize. In terms of the other accusations he's laid at our firm, which don't necessarily go to the merits of this appeal, I would say that I think the record in Superior Court, as Mr. Pareles as a litigant, is evidences the situation and how frustrating it was to litigate this case. In the first appeal that he had of the Framingham case, we did actually not even participate in that. We have not done any action since that time until he then served us with the instant complaint, which is the basis of this appeal. I do believe that the judge got it right. She said the statute of limitations had run. The letter that Attorney Jacobi wrote was a fairly standard letter I've seen among various firms. It's kind of standard to say, look, we're looking to settle. Here's what we'd settle for. If we don't settle, here's possible issues that you might have. And we say, if warranted. If you felt they weren't warranted, then there's no infliction of emotional distress here.
Well, that's not, Counselor, you said we will seek attorney's fees. And you'll also seek the court's advice on sanctions that be warranted. But you said you were going to seek attorney's fees if he appealed a sanctions order that was just plainly lawless. So I don't know that you can claim the moral high ground on that letter.
Well, I'm sorry, again, we didn't participate in the appeal, but the bottom line is, I don't think that that letter rises to the level of emotional distress. I mean, the bottom line is, if you think you've done nothing wrong, then there's no distress there. That's like saying, well, if you lied and told the court that the sky was green, then there's going to be sanctions. You know, and he would know best whether that case warranted sanctions or not, and whether his conduct would warrant sanctions or not. Again, we didn't participate in that appeal. The last thing we really had were those 2 letters in 2016, then there was one subsequently in 2018. At all times, I would note that Ms. Lee was a person of very little means, retired. There was really no way for her even to pay these judgments. And we tried to repeatedly settle the case by saying, look, even if you get a judgment, there's no way that she can pay it. Sort of judgment proof, if you will, just because she doesn't have the funds. And I think the bottom line is, instead of doing that, he decided to bring in our firm with our malpractice insurance, and that could rise the level. In any event, the reality is that he didn't do that in a timely manner. We did have a counterclaim in our favor on that $3,300,000 counterclaim, although we didn't get the damages.
What was the good faith basis for $330,000 counterclaim?
Sure. So she had gone in for a petition to petition, and instead of doing that, he did an equitable complaint. A petition to petition would have been in land court, and that would have dealt on the merits of who paid what. And if the court couldn't hear that, maybe they would have referred to probate court if it was proven in that case that she was married, they were married. Instead, he brought an equitable complaint in the probate and family court, the end result of which was to have it go from it being a petition to petition, where she had paid all the down payments, paid all the mortgage, paid all the expenses in the property. He had not contributed whatsoever, to now you're married, so he has a half interest in that house. And that's what the basis was.
Was it a tenancy by the entirety?
Yes, it was.
Is Mr. Pareles, Attorney Pareles, correct that a tenancy by the entirety cannot be partitioned under the circumstances present here?
I am actually not sure. I don't know.
Well, if he's correct in that representation, then how could there be $1,000 in damages for failing to file a motion that could never have succeeded, or an action that could not have succeeded?
You could still do a petition to petition and reform the deed in land court, which would not have had the jurisdiction to then find that she was married without having her be able to dispute that. So it could have been done in just a different forum, would have been significantly more helpful to her.
Wait, hold on, I'm not following this. If it's a tenancy in the entirety, you could have done what to petition it?
You could have filed a complaint to reform the deed, to clarify that it should not have been entirety, they were not married, and should have been tenants in common or tenants.
But they were married.
They were married.
I don't believe that they were, actually. My personal opinion is they weren't. I've spoken to the chancellor over in Korea. And in the underlying case, what happened was Attorney Parole did do discovery, if you will, in terms of the marriage.
I mean, if that's your position, I don't get how it could be malpractice, because he went right after the marriage and tried to reform the deed. I mean, so where's the malpractice? It sounds like you're saying you should have done exactly what he should have done, and you'd like $300,000 of malpractice money for that.
No, I would have said he should have gone to a different court that wouldn't have the jurisdiction to find that she was married, because I believe she wasn't married. You can file a complaint to reform the deed in land court, and you can file a petition to petition there as well. So if it was addressed there, they wouldn't have had the jurisdiction to then find that she was married. Additionally, in terms of the malpractice, although he did take the deposition of this gentleman, he didn't follow up to verify those facts by even picking up the phone to call South Korea, the consulate there. The gentleman claimed that they were married in a Catholic church in a certain province in a certain year by a certain priest. When I called, they said, we don't have any province by that name. We don't have a Catholic church in that, and certainly didn't have one in anywhere until 1973. The marriage was claimed for 64, and we didn't have a priest by that name in our entire diocese. So regardless of they can find the actual records of the marriage or not, we've proved that where the gentleman claimed they were married, who they were married by, and what church they were married in, none of those things are supported. And that was one of the more frustrating things I had. And I understand the Attorney Parole may not agree, but when I spoke to the chancellor, this particular chancellor did speak English. He was able to say that and confirm that and provide me an affidavit. I did put the affidavit on the caption of the probate course because I was anticipating we'd be able to file that after the appeal in the probate court. So that was the basis that we felt that she wasn't married. It should have been a petition. They should have reformed the deed, and she should not have had to basically give half of her property over to this gentleman who had essentially had stalked her. In terms of the statute of limitations, I think it's very clear. Attorney Parole is a well-experienced attorney. He knew very well what the statute of limitations were. He failed to meet those deadlines.
Can you walk me through? I'm having a lot of trouble with the counterclaims as far as malicious prosecution, because I see Exhibit 8 has the counterclaims, and there's 5 of them: legal malpractice, abuse of process, frivolous claim, breach of contract, unjust enrichment. And then what pops up after trial is judgments on breach of contract and quantum merit. But I didn't see any place where some of those counts got dismissed, or even where quantum merit is in that counterclaim complaint. So,
And you're discussing the district court case, Your Honor, in Framingham?
right.
Okay. My recollection, and I'm going by memory only, Your Honor, is that we had pretrial discussions and the judge said he was not going to submit those to the jury. So essentially they were dismissed, if you will. And in the malicious prosecution, he didn't give that to me. He said, it's not timely. I'll discuss that at the close of the trial. And then I made the oral argument at the close of trial that we should be bringing a malicious prosecution. And Attorney Parole was correct at that time. I did not realize that it did not cover cases in district courts because I usually practice in superior court. I didn't realize there would be a carve out for the district court for whatever reason it was. So that is what the judge ended up doing procedurally. That's my recollection, and he can correct me if he has a different recollection.
And about when did that happen? About when trial? Like close to trial?
I think it was about a month before. It was when he actually scheduled the trial date. It might have been at the pretrial conference. I don't recall the exact time of that, but it was about a month before.
Okay.
I actually don't have any other arguments unless you have any specific questions for me.
And seeing none, Justice Ditkoff, anything?
Nope.
Seeing no further questions.
We are live and on the record.
Calling our final case of today's sitting. It is docket number 2020 P1247, Mcdermott versus Massachusetts Parole Board. We will hear first for our counsel, or from counsel for the appellant, Attorney Tawari.
Good afternoon, Your Honors. Thank you. My name is Chetan Tawari. I represent Mr. Mcdermott, the appellant in this matter. Mr. Mcdermott was denied parole for the 5th time in 2018 and given a 5-year setback. The decision the parole board issued was effectively pages of boilerplate language minus 3 sentences of actual reasoning. And those 3 sentences stated 2 reasons for why he was denied parole. One was the parole board was concerned about Mr. McDermott's motive for the crime. And second, that he had reduced his attendance for addiction treatment. Neither of these statements are supported by the record. And understandably, the parole board is granted considerable deference. However, upholding this decision actually grants them absolute deference. If this decision is upheld, then it opens the door for the parole board to effectively take words from the record, snippets, sentence fragments from the record, and try to conjure up a reason to deny somebody parole. And in the appellant's reply brief, I focused on 4 specific instances where the Commonwealth really just misshaped the record. And for example, they stated that they were concerned about Mr. McDermott's lack of support if he were to be paroled. And they cited a statement that he had no contact with his siblings for over 20 years. That statement is patently incorrect. He stated several times he has regular contact with his brother. His brother has offered to provide him money and send money to him while he's in prison. What the statement was that he has not seen his family in over 20 years, and that's because his brother and sister both live out of state. They live on the West Coast. So this has been what the parole board has been doing. They've been taking this record and shaping it in a manner that just doesn't make sense. It doesn't fit the standard the standard that they need to meet. That's not arbitrary and capricious. Another example is they state that Mr. McDermott was inconsistent in testifying with respect to his motive for why he committed the crime. And they again pull fragments from the record that quite frankly aren't really inconsistent. For example, they'll say that the Commonwealth argues that at one point, Mr. McDermott argued that he was drunk when he committed the crime, but then said he only had 2 beers. Those two are not mutually exclusive, especially for a 17-year-old, and he was 17 at the time. And this is probably one of the biggest examples of how the parole board's decision doesn't hold up. The board states it's concerned, actually, I'm just going to read the sentence from the decision directly. For decades, he, being Mr. McDermott, perpetuated lies and defamed the victim. And there's actually a recent decision from the Superior Court. It came out December 23rd, 2021, just a few weeks ago, where Justice Krupp states that this is a troubling justification, where in that case, the board also reasoned that they were concerned about the motive and the fact that the individual wasn't more forthright with his motive for years. And Justice Krupp writes, this is a troubling justification because arguably this justification can be used to deny somebody parole in perpetuity. Mr. McDermott wasn't forthright until 2012, decades after he was convicted. 2012 was the first hearing where he said, I committed this crime. It's in the record that he said, I committed this crime and these are my reasons. And they want to hold it against him that it took him decades to come to that realization. Now, that doesn't actually have a bearing on whether today, in this instance, on this day in 2022, does he meet the standard for parole? Will he live and remain at liberty without violating the law? And is his release compatible with the welfare of society? The fact that he took so long to get to this point has no bearing. And for them,
why doesn't have bearing? I mean, if he had admitted and shown remorse from the beginning, versus going to 3 parole boards, perpetuating this lie about being raped by the victim, why aren't those different situations in figuring out whether he's rehabilitated and how likely he is to commit another crime?
So, Your Honor, I think looking at how long it took Mr. McDermott to get to this point, although it is a factor to be considered, Mr. McDermott has been stating this for 10 years. He's been stating the same motive that, I believe in the record, he clearly states, I shot him. I shot him because I was trying to rob him. And he states that in the record, and he's been doing that for 10 years now. And for the parole board to say, okay, yeah, but those first 20 years, they're starting to get into a punitive role where they're punishing him for something that he had done while he was already incarcerated. He's come to the point now where he has been very forthright and very forthcoming about what happened that day. And I don't see the logic in them saying, okay, well, you just didn't come to it soon enough. And for them to do that, for the parole board to get into that line of reasoning, they're starting to punish him for something that he is no longer doing. And that's not their role. Their role is to determine, is his release compatible with the welfare of society? So I just don't see how that line of argument has any bearing. And the parole board doesn't really explain it either, because they don't really go into why they use that to support their denial of his parole.
Attorney Tamari, I have a couple of questions, and I understand the argument that you're making now, which is essentially that the parole board is cherry picking various facts and putting them into what you would call a non-cohesive narrative that you think isn't supported by the true record. I hope I'm stating that correctly, but it seems to me your central argument in your brief was that there's a Diachenko violation here because the board's written decision shows just a cursory review of the Diachenko-Miller factors. Is that correct? Is that the crux of your argument?
Your Honor, I'd say that is actually a secondary argument. I think
that's the secondary argument.
Yeah, the crux of the argument is that they abused their discretion. It was an abuse of discretion because the decision was arbitrary and capricious by the fact it's not supported by the record at all.
Okay. So that's very helpful. So first argument is it's not supported by the record. Second argument is cursory findings in the written decision.
That's correct, Your Honor.
Okay, so then that makes this easier. But then my only question then is, am I correct that we are not limited in our review to looking at the parole board's written decision in terms of analyzing whether or not it properly considered the Diachenko-Miller factors? In other words, we can also look to the transcript of the hearing, the questions that were asked, the answers propounded, etc. We can look to the record and not just the written decision itself. Am I correct?
You are correct, Your Honor.
Okay. So it seems to me that your second argument about the cursory review really relates to the concurring opinion by Chief Justice Gantz and Justice Link in the Deal case, right?
Yes, but also the two cases I cited, minor child number 1 and Hagberg, which do discuss that when it comes to a constitutional decision, which this is, there must be a detailed, meticulous review. And I don't understand how 3 sentences would qualify in a situation like this.
Thank you. Those answers are very helpful. Thank you.
And so just continuing on, the board also did not. Oh, sorry, I thought I heard some feedback there. The board did not. The board also discussed the alleged lack of attendance to addiction treatment. Now, this is an important point because a lot of the parole hearing was focused on that, and we get into a situation where the board starts moving the goalposts. The DOC informed Mr.
Counselor, I guess I have a question about that, because in 2013, the board says he has much work to do to identify and achieve rehabilitative goals. And then at the parole hearing we're reviewing, he's asked, have you participated in any additional programming? And he says optical and AA. And optical, of course, is vocational. AA, he's not attending regularly. So what the board ultimately finds in this case is that he has not demonstrated a level of rehabilitative progress. And what is inaccurate about that? It seems, if anything, he was told to identify and achieve real rehabilitative goals. And if anything, he seems to have gone backwards a little over 5 years. Why isn't that supported by the record?
So, Your Honor, part of the record is also the DOC's opinion of what he should be doing to further rehabilitate. And one of the things which is explicitly stated in the record is that the DOC believes he no longer requires addiction treatment. So what he did with that information was he focused on the vocational side. In his CRA course, which he did complete, it states that one of the principles of life is work ethic, self-reliance. And Dr. Joss testified to this as well, that Mr. McDermott's focus on employment on the vocational side of rehabilitation is actually good for him. And it's good for his recovery from addiction because it gives him that self-confidence. It gives him the self-reliance he needs to keep moving forward. And what happened, the reason he stopped was, one, the DOC said it's not necessary, but two, he was transferred to the optical the optical department. And the working hours for that department conflicted with the AA meetings. So it wasn't as if he was, he was told to do two things. He was told to, you don't need to go to AA, but you should start working more. So he started working more at a time when it conflicted with AA, and he didn't feel that was a conflict because he was told he didn't need to go to AA.
That's not what the board told him. The board told him to achieve more rehabilitative progress.
And I think this is also where we get into some confusion why the board should be upheld to a higher standard with having better decisions. Because when this individual who's been incarcerated for almost four decades now, he's told, do better by the board. But then he's told by the DOC, the people who see him and he works with every day, you don't need to go to AA, you need to work more. He starts working more. And there's a clear miscommunication there. And so
I mean, the board and DOC seem to disagree all the time. I see the board ordering step downs that DOC refuses over and over again. Why does the board have to defer to DOC?
I think the board, I wouldn't make the argument the board has to defer to the DOC. However, if Mr. McDermott's constitutional rights to a proper application to parole are to be respected, there needs to be some clear information given to him, not constantly moving the goalposts or switching what he needs to do to prove that he is parole eligible. And so back to the point about the reduction of addiction. So they're saying they're concerned with his reduced attendance. However, Dr. Joss has explained, and the expert that was retained to testify, to evaluate Mr. McDermott and testify on his behalf, stated that he is doing what he needs to do. He has a support structure he's doing what he needs to do to remain in recovery. He has a support structure, he's working, he's becoming more self-reliant, he's becoming more self-confident. And then I think this is an important point. The Commonwealth stated that Dr. Joss was concerned that Mr. McDermott had issues of paranoia, which may cause him to recommit a crime if he's released. And that's just completely incorrect. What Dr. Joss said was that Mr. McDermott exhibits symptoms of paranoia, but that's because he's been incarcerated since he was 17 years old.
Well, Dr. Joss said it may be reflective of the long years of incarceration. Doesn't that allow the possibility that it may not be reflective of that and maybe something he had before?
It would if that was in the record, but that's nowhere in the record.
I was just reading the report in the record.
Oh, no, sorry, Your Honor, what you said is in the record, but him having paranoia and that may cause him to commit another crime, that argument is not in the record, and the Commonwealth pulled that from I don't know where.
I get you.
I see my time is coming. My time is coming to an end. With permission, I would like to file a Rule 16L letter citing the Superior Court decision that came out last month, and just providing that because I do believe it's very on point and informative for this panel.
You may file it, and then we'll rule on whether we accept it, and we'll go from there.
Thank you.
Please file it. Thank you. We'll now hear from counsel for the appellee.
May it please the court, Assistant Attorney General Tara Johnston on behalf of the Parole Board. Your Honors, the motion judge here was well warranted in finding that the board's decision was neither arbitrary nor capricious nor clearly erroneous. The board did as required under Massachusetts General Law, Chapter 127, Section 130, and gave a summary statement of the case with the reasons for its decision. Here, the reasons for its decision are that the board was concerned with the plaintiff's motive for the crime, including his decades of lying and defaming the victim, and the plaintiff's recent abstention from substance abuse programs and treatments in the recent months preceding the parole hearing. These decisions were clearly supported by the facts set forth in the decision and also by the testimony at the parole hearing, as well as Dr. Joss's report, which was submitted on behalf of the plaintiff. First, with respect to the motive. The cases make clear, and I ask this court to refer to Commonwealth versus Deal, SJC case, 2020 case, discussing what was considered in that case, and in that case discussing how it was reasonable for the board to come to the conclusion that they did, because the plaintiff, the individual's explanation about why he committed the murder was not plausible. Here, and also I asked this court to look at General Law, Chapter 127, Section 135, where it says that the board, in deciding a parole, is to be given by probation all of the facts of the underlying crime. This is something, the underlying crime and the facts of that crime is something that is considered at a parole hearing. And Deal makes clear that this is essential to in the analysis of whether someone it's appropriate to grant the person parole. Now, certainly other factors need to be considered, especially when dealing with a juvenile homicide offender, the Miller-Diachenko factors, but that does not ignore that motive and the person and the individual's decades of lying about why they did this crime is important. Here, first of all, according to the plaintiff, what the plaintiff said at the parole hearing, he murdered this person in cold blood. He shot him 11 times. Someone who he said was extremely kind to him, gave him money when he couldn't pay for the cab, gave him a job, was very kind to him, this individual, and he just shot him in cold blood 11 times. He reloaded the gun to shoot him 2 more times after he shot him 9 times. Then he threw his body.
Counsel, you're making a fairly emotional argument here, and as terrible as this crime was, and as terrible as is what Mr. McDermott did to the family in the aftermath, the whole point of this is that, you know, he was a juvenile at the time, and people change. So I don't know this is the strongest read. I'm way more interested in the rehabilitative progress that was center of the parole board's decision here.
Of course, Your Honor. So I think that one of the things that the continuing concern about the motive, you're right? Someone can change, and that's first of all, we have to consider that within the Miller-Diachenko factors, but also what we know from and we have to look at the transcript as well. That's part of the record, and that is in it's clear that the parole board members are also concerned about with regard to the motive. Is not just the motive for the crime, it's not the motive for the crime at the time, but the fact that the plaintiff himself can't give a clear explanation now of the motive of why he murdered this person. In 2012, he tells the parole board that he was drunk, that it was purely because of intoxication. He's drunk when he commits this murder. But then here he tells the parole board, and he does, contrary to what my brother says, he does give numerous inconsistent statements. He said, oh, maybe I had a couple of drinks and a joint. I wasn't on drugs. At points during the hearing, he says the only way I could ever act this violent and do these things is because I was on these drugs. But then he says I wasn't on these drugs when I committed this murder. Right? I had a couple of drinks, maybe I had a joint or two. So he's denying being drunk, being intoxicated, which was the original reason given. He says at times that it was because because of his addiction and he wanted more money for drugs, so that was the sheer motive. But then when he's asked why he shot the victim, why he needed to shoot him 11 times for that, when he was stealing from him continuously over this period of time, there was no need to do that. He couldn't give a clear explanation. He also at times during the hearing said that it was because he was transferring the anger he had with his father, who was extremely violent to him, when in fact, Mr. Kemp, the victim here, was never violent to him. And he admitted that he was always very kind to him. The board throughout the hearing, if you look at the transcript of the hearing, repeatedly the board members expressed confusion and are disturbed by the fact that the plaintiff keeps giving Mr. McDermott keeps giving inconsistent answers throughout the hearing, keeps contradicting himself when they ask him when
so does that speak to? Sorry to interrupt, but does all of that speak to motive, or does all of that speak to a board that is simply making determinations that Mr. McDermott is not being credible?
Well, I think it goes to both. I think it goes to the motive because the fact that the Mr. McDermott continues to give inconsistent answers about the motive, about the underlying crime, about when he even decided to commit the murder, and he says it. I think that all of that goes to both. I think it goes also to the decades of him lying about what happened. Yes,
well, let's talk about that. You seem to be saying two things. One is that Mr. McDermott is providing inconsistent responses, both in relation to what he testified to before the parole board and in relation to his prior representations, correct?
Correct, Your Honor.
So assume, and we certainly have not decided this case, assume we agree with you though, and in 2 years he has another hearing. Well, you've already said what you've told us isn't good enough. So then he comes back and he gives an explanation, and so then the board's going to say, well, that's different than what you told us the last time. I mean, it almost can never end using the analysis that you're putting forth.
I think that it's up to the board. So the
Do you
board,
understand the concern? And
I do.
Attorney Tawari makes a very good point in this regard.
I do.
I mean, it's setting up almost an impossible boundary or an impossible hurdle to overcome.
I do, Your Honor, but I also think that it's not arbitrary and capricious. And I think that it is reasonable for the board to take into consideration that even if you look aside and you say, okay, let's look aside from the 2012 hearing, let's look aside from what he said before, let's just look at what he's saying at this hearing. Even if we say that throughout this hearing, this one hearing, he gave repeatedly inconsistent answers. They contradicted themselves. At one point, he says that he didn't know when he didn't have any plan to kill the victim until it started happening. At another point, and during that same hearing, he says he made that decision when he found the gun in the desk. He can't give a real explanation as to why he even took that gun, except he says at one point that it made him feel good. It made him feel stronger to have a gun with him. At times, he said he doesn't know anything about guns. He says he shot this gun on previous occasions. I think this all, it goes to motive to the extent that, and it goes to his decades of lying about what happened. Yes, now he's not continuing to defame the victim by saying the victim raped him, but he's continuing to give contradictory answers about the underlying crime. And I don't think that again, the standard here is whether the board's decision is reasonable, whether it's arbitrary and capricious. I think that it's reasonable for the board to come to that conclusion that this is problematic. And it was problematic that this individual who, again, committed this heinous crime, who lied for years about it, is still at this point in time giving contradictory answers about his motive, is continuing along that line of perpetuating lies. It may not be the same lies, it may not be as bad of lies, but lies about the reasons and the fact that he just can't give one straight explanation. And maybe that's something he hasn't come to terms with himself, but regardless, he still can't give a clear explanation that's consistent to the board about why he committed this murder. Also, I think that, and then the second reason, I think this is very important, is that this individual has failed to attend substance abuse programs within recent months of the parole board hearing. At one point, he says it's 3 months. There's no date. It's made clear, and this is discussed at the hearing itself, that at the prior hearing, even at the prior hearing that he had before the parole board, the parole board notes, wasn't the board previously concerned with your sporadic attendance at substance abuse programs? And he kind of gets around that question and says, oh, but I attended it. But it's conceded, right, that they were concerned before about his sporadic attendance. And even though he was aware of that fact, even though he was told that he had to, before this by the board, that he had to go through more rehabilitative programming, even though he states that he was told by classification at one point that he needed to go through anger management training, which he admits he never did because it conflicted with his job schedule. He fails to do all of this.
Counselor, your brother is right that it is a problem, not necessarily for adjudicating this case, that DOC and the parole board are on different pages here and so often. I mean, I know you represent the parole board here, but you represent the whole Commonwealth.
Right.
It's certainly problematic. How do we deal with that?
I think, so here we're looking right at, he knows what the parole board is looking for. And I think, yes, I don't disagree. I think though that the DOC is looking at different things when DOC isn't evaluating what he needs to get parole. So I think that they're looking at two different evaluations. The DOC may come to a different determination, but it's clear throughout that the parole board has made clear to this person. I would agree that if the parole board had not made clear to the individual, this is something he needs to do, but the parole board had made clear to the Mr. Mcdermott that this is something he needed to do repeatedly. They were concerned even at a prior hearing about his sporadic attendance. The fact that he is not listening to the parole board about this being necessary is problematic. The parole board feels that this is necessary for his release. This is necessary for him for his release with being in the welfare of society and him not being reoffending. And
is there any dispute that he hasn't had drugs or alcohol in over 30 years?
I don't think there's any dispute about that, Your Honor. I think that he states that there's nothing in his record that suggests he has. So I don't think there's really any dispute there about that. But one thing I also want to mention, I know my brother mentions that Dr. Joss's report supports him, but I think my brother overstates how much Dr. Joss's report and how much Dr. Joss's testimony actually supports his position. It's clear, first of all, Dr. Joss, and this is something my brother does not know, Dr. Joss is also extremely concerned, he even states it in his report, that it is concerning his abstention from substance abuse treatment, substance abuse programs, and that is important to his progress and he would need to be attending those upon his release. So that's recognized by Dr. Joss himself, someone testifying on behalf of the plaintiff here. Also, when we look at why it's so important for this person, why it was reasonable and not arbitrary and capricious to find that the plaintiff here needed to Mr. Mcdermott still needed to be attending these programs, we have to consider the fact of the reason, right? One of the main reasons given by Mr. Mcdermott for this murder is that intoxication. He himself states during this hearing, that is the only thing that makes me violent, is my addiction to to drugs and to alcohol. And yet we have someone saying this is what makes him violent. The parole board knows the heinous crime he committed when he was under the influence of these drugs and alcohol, or he claims to have been, or at least he was addicted to them. And yet he's failing to attend these substance abuse programs that would help him. Also, he himself says, and I want to make clear something, because I know my brother states, the board misstates what his support network is like. So again, Mr. Mcdermott gives contradictory answers during the hearing itself. At one point, he says that the last communication he had with that brother was a year ago. Then at another point later on, he says, oh, instead of contacting him every 3 months, I would contact him maybe once a week. It's completely unclear when his last communication with this one brother was. He makes clear he doesn't have much of a support network. He hasn't seen any of these siblings, whether they live far away or not. He has not seen them for 25 years. They've said they want nothing to do with this.
Your time has expired, but you can finish your last thought. But
I would like to touch on the military factors just really quickly here. The board.
I'll give you 20 seconds. Go ahead.
The board clearly considered them. I asked this court to look to Commonwealth versus Deal, what is necessary to satisfy that standard. The board not only stated that it was considering those factors, but also in the statement of the case lists all of the factors of the Mr. Mcdermott's youth that connect to those reasons. And I asked the court to look at that, and otherwise the rest of my brief. Thank you, Your Honors.
Let me just check Justice Hand, Justice Ditkoff. Any further questions?
No, thank you.
I'd like to thank counsel for both parties.